Supreme Court has just issued a 6-3 decision that every gun owner across America needs to pay attention to right now. Imagine this. You're heading home after work. You see flashing red and blue lights behind you. A police officer stops you because you were driving 5 miles over the speed limit. The officer approaches your window, takes your license, and walks back to the patrol car. A moment later, he returns with a different expression. Instead of simply giving you a ticket, he looks at you and says 4 words that instantly change the situation. Step out of the vehicle. What happens next can decide whether you return to your car and continue driving, or whether you unknowingly give the officer information and opportunities that could lead to a search, testing, or even an arrest. The surprising part is that many people do not understand the difference between what the law requires them to do and what an officer is only asking them to do. That small distinction can completely change the outcome. When an officer tells you to leave your vehicle, many people assume they have no choice but to immediately comply with everything that follows. But getting you outside the car changes the entire situation. The reason is simple. Once you're no longer inside the vehicle, the officer has a different view and a different level of access. The first thing that can happen is the officer may now have a clearer view into the inside of your vehicle. Something that was harder to see before, like a bag, a container, or an item sitting on the seat, may become visible. Under the plain view doctrine, items an officer can legally see may become a reason for further action without needing a warrant or your permission. Simply leaving the vehicle can change what the officer is able to observe. The second thing that may happen is the officer could begin asking questions or requesting additional tests. If the officer believes there may be alcohol involved, you might be asked to complete field sobriety exercises. That could include walking in a straight line, standing on one leg, or following an object with your eyes. A lot of people cooperate because they believe they are required to do whatever the officer requests. The third issue involves a possible pat-down. Even after you pass those sobriety checks, the officer may say a quick search is needed for safety reasons. This is known as a Terry frisk. Once physical contact begins, the officer is checking for possible weapons and evaluating what he feels during the search. And then comes the biggest factor, talking. Many people become nervous once they are standing outside the vehicle with traffic moving around them and an officer watching closely. That pressure often causes people to start explaining. They say things like they did nothing wrong, where they were coming from, or details about what they may have consumed. Every statement made during that interaction can become part of the evidence. The officer is documenting those words and deciding how they fit into the situation. The problem begins when people react out of fear and immediately agree to everything. The officer says, "Step out," and they respond without thinking. Step out? Sure. Walk the line? Many people say yes. Search my vehicle? Go ahead. They believe complete cooperation will make everything end quicker. But that is not always how it works. Then there's the other reaction. Some people refuse everything. They say, "I'm not leaving my car. You cannot force me. I know my rights." But now the officer may document the encounter differently. The report could say the driver was hostile, argumentative, or refusing to cooperate. Those descriptions can become part of the official record. And if someone reacts in a way the officer views as suspicious, the officer may claim there were unusual movements or behavior that created enough concern to justify additional action. Now consider the situation from the officer's side. This is something they handle every day. It is a familiar procedure. They know that a person outside the vehicle is easier to watch, easier to evaluate, easier to interact with, and potentially easier to detain. Once someone is standing beside the road, stress often takes over. People begin explaining. They start answering questions. And those answers can become part of the investigation. An officer does not have to remind you that your own words may later be used as evidence. In many situations, the officer may appear calm and friendly, encouraging more conversation. The goal is to keep the interaction going and gather more information. Now here is the part many people do not know. Under the Supreme Court decision Pennsylvania versus Mims, an officer is allowed to order a driver out of the vehicle during a lawful traffic stop. The reason is that the court determined officer safety concerns can outweigh a person's expectation of remaining inside the vehicle during that stop. Later, the Supreme Court expanded that rule, allowing officers to also remove passengers from the vehicle. So the important point is this: if an officer legally orders you out of the car, you are required to comply. That issue has already been decided by the courts. But this is where many people misunderstand their rights. They believe that once they step onto the roadside, they have surrendered everything. They think they must now agree to every request. That is not correct. Leaving the vehicle does not mean you have given permission for a search of your car. You do not have to answer every question. You do not automatically have to agree to field sobriety tests. Your constitutional protections do not vanish simply because you are standing outside the vehicle. There's another important point. Under Terry versus Ohio, an officer may only conduct a pat-down when there is reasonable, explainable suspicion that the person is armed and dangerous. An officer cannot simply search someone because they are standing nearby or because they want to. There must be a specific reason connected to safety. This creates a difficult situation. The law may require you to exit the vehicle, but you can still refuse consent to searches. You can still choose not to answer questions. You can still protect your rights. The challenge is knowing exactly what to say in that moment. How do you follow the officer's lawful order while making it clear you are not giving up your rights? The answer is simple. Remember these words. The words you want to use are simple. Officer, I am stepping out because you requested it. I do not give consent to any searches. Am I free to leave, or am I being detained? Now let us look at why each part matters. Saying you are stepping out because the officer instructed you shows that you are following the law. You are not arguing. You are not refusing. You are not creating a situation where the officer can describe you as difficult or suspicious. The next sentence is where you draw the boundary. You clearly state that you do not agree to any searches. You are making your position known. If the officer later searches you or your vehicle without proper legal justification, the issue of consent becomes important. Then comes the final question. Am I free to leave, or am I being detained? This forces the officer to define what is happening. If you are free to go, then the encounter should end. If you are being detained, the officer must have a legal reason for continuing. The responsibility shifts back to the officer to explain the basis for holding you. But what happens when the officer pushes back? Because that is something that can happen. The officer may say something like, "Look, I can let you go, but first just do these quick tests." At that moment, you can respond, "Officer, I am choosing to decline field sobriety tests." That is all. Field sobriety tests are voluntary. Even someone who has not consumed alcohol can still perform poorly on these tests. Now imagine the officer says, "If you have nothing to hide, why not let me quickly search your car?" The answer is simple. "Officer, I'm exercising my constitutional rights." Those words alone are not evidence of wrongdoing. Using your legal protections cannot be treated as proof of guilt. But what if the officer ignores your refusal and continues anyway? What if the officer pats you down or searches your vehicle without proper cause? Do not turn that moment into a confrontation. Do not argue physically. Do not raise your voice or make movements that could give the officer a reason to accuse you of resisting. Instead, calmly repeat that you do not consent to a search of yourself or your vehicle, then stop talking. The roadside is usually not where these legal battles are decided. Those fights are handled later, in court or through a civil rights claim if one is available. Knowing the rules matters. Recognizing what is happening matters. Knowing what to say and when to say it can change the outcome. That difference can determine whether someone leaves the scene normally or ends up facing a search, a damaged vehicle, or even an arrest. But there is another situation you need to understand. What if the officer does not ask you to step out? What if the officer comes to your window and says, "I think I smell alcohol"? The next step is knowing the exact response to that situation and how to protect your rights when that claim is made.